Hi, thank you, Mac, and thank you, Paul, also, and to the Lexington Institute more generally. So I'm Ashley Baker, as Mac pointed out. I'm Director of the Committee for Justice. For those who don't know us, we work on constitutional law issues and the courts, including judicial nominations, but a lot of my personal work, so it can concerns antitrust and the institutions that enforce it. That includes the FTC, obviously the DOJ Antitrust Division, and increasingly the more than 50 state attorney generals. So I'm going to address the state AG issue right now. I know this is not the most, fun, exciting topic compared to some of our previous speakers here, but, save the more interesting, wonky thing for last, so to speak. I would say that I don't have as interesting a story as, personal anecdote as Adam had, for example, about this, but one kind of quick aside. So when it comes to kind of my personal view on state AG enforcement, so I was testifying in front of the Senate Judiciary Committee a couple of years ago, and they did that thing where, one member of Congress, a Democrat in this case, who's a senior member, who asked, answer the following question, yes or no. You can only say yes or no. I hate it when they do that. So it's like such a stupid exercise. But anyway, the question was, should the states have brought this state, suits against, lawsuit Google, against Google, Meta, etc. And my yes or no answer was yes, because they do have the authority to do so, and I very much stand by that, and that they have the authority. And it would strike me as the wrong answer to say otherwise. However, I have a lot of caveats about that, which I'm about to get into, especially arising over the next year or so. That this has become more and more of a trend. So enforcement is kind of overall, it's migrating from accountable national institutions to 50 plus political actors who all, I should probably note, they all have treasuries to fill at the state level. It's accelerating on every metric that you can measure, and the consumer benefits are at best really hard to find if you look at the actual data. So according to the National Association of Attorney General's NAG's litigation database, one of many, state AGs initiated 7 antitrust enforcement actions just in the first half of 2026. That was more than they filled in all of last year, or the year before that, or the year before that. And antitrust is obviously only one docket that the state AGs are supervising here. The same companies face multiple state privacy suits, which we'll get into in a few minutes, consumer protection suits, and child safety suits, often all these things simultaneously. So the multi-state machinery is kind of is bigger and bolder too, more recently. So in February, 42 states and territories filed a new price fixing suit against Novartis, and more than 30 states recently settled generic drug price fixing claims for $178 million. So this goes way beyond the tech companies. This goes into every aspect of consumer protection and antitrust. And this is because the machinery is working, but now it's kind of more pointed at technology companies. So there are 3 kind of specific developments over the past, or more than 3, I guess, over the past year that deserve your attention. Whatever you may think about big tech when it comes to state AG enforcement. First I'm going to cover is the Live Nation Ticketmaster lawsuit. For those who aren't familiar, the Justice Department took the case to trial on March 2nd and settled at mid-trial. In that case. So more than 30 state AGs, and in this case, it was a genuinely bipartisan coalition. There's a lot of momentum against Ticketmaster, I will admit to that. They rejected the federal settlement as too weak, but they kept litigating without the federal government in this case, which is a little bit unique in these sorts of cases. In April, they wanted jury verdicts under both federal and state law. They're now demanding Tuning Act discovery in the DOJ's own settlement. So think about what that means more broadly. So the states are no longer supplementing federal enforcement, which is what they used to do. You'd have a suit that was brought by the DOJ, brought by the FTC, and the states would kind of piggyback on that, or vice versa. They would supplement each other. They'd supplement each other in terms of how much enforcement resources they could spend on that. But now they're kind of litigating against the federal government's own judgments in cases. So second, I'm going to take a look at kind of this when it comes to merger enforcement. So the Nexstar Tegna's merger was a $6.2 billion broadcast deal that the DOJ and FCC both reviewed, and they both approved. 13 states, including Republican AGs from Indiana and Kansas, are suing to block it anyway. And a federal judge has frozen integration while the Ninth Circuit considers the appeal. And I can't, this is something I've been kind of looking at recently whenever it comes to some of the other suits, such as like the Paramount lawsuit, is that TRO and that the PI grant in that case from the judge really emboldened state AGs. And I think this is like a really important thing to look at, because they see this case and they think, well, okay, we have a chance at getting the preliminary injunction, and in some cases they might very, very well do so. And kind of back to my previous point, so just this month, or last week actually, so 12 states sued to block Paramount's acquisition of Warner Brothers. And that transaction very much kind of piggybacked off the fact that there was the injunctive relief in the previous deal. And then we had, a year ago, we had the Kroger-Albertsons case. Washington State enjoined a national grocery merger under its own state statutes, and the deal eventually died. And then there's kind of the general point too, and those who are part of the antitrust defense bar now saying, well, federal clearance is not the green light that it used to be. I mean, it was never completely a green light, but now they are very much not safe from the state AGs. And I think this is a much broader problem. And the third issue here is that the infrastructure is becoming more permanent through state legislation. So California, Washington, and Colorado have enacted state pre-merger notification statutes. New York, Hawaii, Indiana, West Virginia, and the District of Columbia are considering their own as well. New Jersey just stood up a dedicated antitrust enforcement section. New York enacted the nation's first algorithmic pricing law back in November, and its AG demanded Instacart's pricing records in January following that. Maryland followed with its own statutes, very similar to that. So this is becoming a bit of a cycle, and a bit of a build-out, in that the dominoes are falling here. So if you kind of put this on the technology docket specifically and apply this to tech companies with the broader theme of why we're here today, so let's look at some of the more recent tech cases. In the Google search case, where the states were the co-plaintiffs, Judge Manna declined to break the company up, obviously, last September, and ordered data sharing remedies instead. Both sides have appealed. In ad tech, the judge's remedies decision is pending in Virginia, while in Texas, 15 other states represented in part, and I think this is a big deal that doesn't get enough attention, is they're represented in part by contingency fee private counsel by the plaintiff's bar. Take their separate ad tech claims to a jury in the Eastern District of Texas next month. Meanwhile, although the FTC actually lost yet another case in November when Judge Boasberg held that the agency failed to ultimately prove its monopolist claims against Meta, and that I know that kind of oversimplifies things in the interest of time here. The FTC is now appealing that case. But Meta's real exposure here is not to the federal government or to Judge Boasberg. It's that more than 40 states are litigating youth safety claims against the company. On June 30th, those state AGs won partial summary government judgment under COPPA, and the trial on that begins next month. And Meta says the state's demand approaches $1.4 trillion, like trillion with a T. That happens to just coincidentally be exactly the market cap of the company. They're saying, basically, hand us your company, and as a remedy in this lawsuit, which is absolutely ridiculous. And then you have 14 state AGs have parallel suits that are more or less the same against TikTok. And Texas alone has extracted $1.4 billion from Meta under biometrics and law, and $175 billion from Google over privacy. So we've seen this kind of play out in privacy law over the years. Maybe we saw what happened in Illinois. We now see this in Texas as well. We start with Illinois under BIPA, but looking at more broadly at this, we have to look at the incentives of the state AGs and kind of the history. So kind of by way of background, Congress gave state AGs authority to bring antitrust federal suits in 1976 and the HSR Act. So since California v. ERC in 1989, states can stack indirect purchaser remedies under state law on top of federal damages. There's several cases that led to that. The tools were kind of always there, but what's changed really here is just the politics. Federal enforcers are perceived, whether it's fairly or not, as kind of taking a standoffish approach in this administration, that they are kind of pulling back. And then with that vacuum, there carries rewards, in both parties on the state level. AGs or aspiring governors are called that for a reason. So 5 Democratic AGs held a joint press conference, for example, in May, promising to fill federal enforcement gaps, which says all the quiet parts out loud of what they kind of want to do. You add on to that kind of the contingency fee outside counsel, the plaintiff's bar, and settlements that flow to state treasuries, and this has become more or less a machine in recent years. And we've seen this play out in other areas of the law, but right now it's like particularly targeted towards tech companies. And so another part I should address here, though, is kind of the federalism claims, and especially myself as a conservative, and I would say that we are federalist, or at least I am. And should we be concerned about this, or should we not? And kind of the point that I want to make here is that federalism does have a structure. So states, as laboratories of democracy, work when the effects of this experiment stay within the state. And digital markets and the internet more broadly are national and global when states' rules become everyone else's rules. After national pork producers in 2023, the Dormant Commerce Clause is not much of a check on extraterritorial state regulation, which will become a pretty big problem. Judge Posner actually saw all this coming more than 20 years ago, and he argued that states should be stripped of their authority to bring federal antitrust suits because, in his AGs, in his words, and I'm quoting him directly, are subject to parochial political pressures and use antitrust enforcement for headlines. And he was exactly right about that. 20 years later, he proved to be correct on that. Another structural point about these lawsuits, or legal point on these lawsuits, is that more than 35 states have repealed Illinois break-by statute. So a single course of conduct can now generate 51 lawsuits in 51 forums under 51, well, more than 51 technically, legal standards with no preclusion across them. And no other advanced economy in the entire world looks at competition law this way. Even like Brussels, like of all places, centralizes enforcement into a single commission. And you can probably tell I'm a little bit of a fan of the unitary executive, but I think that would serve us well here. We're running a much more fragmented competition regime than the European Union, and no one here in the United States voted for that. No one voted for the effect that that would have on consumers. So my final point is, like, do consumers benefit? And I think you have to kind of look at where the money goes. And like, to give credit where credit's due, the Play Store, the Google Play Store, the state lawsuit, 630 million of the 700 billion allegedly went to consumers. If that ends up playing out, then that at least went back to consumers. But look at Texas's privacy settlements. Nearly $2.8 billion combined in all of the privacy settlements went to the state treasury with no direct consumer restitution required, and outside counsel definitely took their fair share in those cases. The remedy states seek largely to duplicate federal relief, and the empirical literature finds little evidence of this kind of enforcement has raised consumer welfare at large. The costs by contract are pretty concrete. 50 state compliance patchwork functions as a tariff on national commerce, paid ultimately by consumers and startups, not incumbents. Incumbents can afford, obviously, 50 compliance departments. If you're Google, if you're Meta, if you're Amazon, if you're a large company, then you can afford to comply with these laws, whether it's enforced by the Brussels, although their fines have gotten kind of extravagant, particularly as of yesterday, if everyone's probably in the news against Google, the $1 billion, but they can afford to comply, whereas startups very much cannot. So I'm going to kind of close here with Europe, because Europe kind of ran, like I just said, this experiment for us. The EU built exactly this kind of layered, discretionary, politicized enforcement apparatus for technology. Europe has produced no trillion-dollar technology company. America has produced half a dozen, and American startups raised several times the venture capital of all of Europe combined. If we replicate Europe's regulatory model here out of frustration with particular companies, we should expect Europe's results. The answer is not that states have no role. It is that Congress has a job. National rules for national markets on privacy, AR, or mergers should be enforced predictably by accountable national institutions. The Commerce Clause exists because 13 states learned the hard way that the 13 trade regimes made everyone poor prior to the Constitution. under the Articles of Confederation. So 51 antitrust regimes for a national digital market is not federalism. It's fragmentation, and that's kind of my endpoint here is that these state AG lawsuits are something to watch. And for those who care about federalism, you should also still pay a lot of attention to this.